There is one other case that I would talk about as a precursor to Dred Scott, which is 1842 case called Prigg versus Pennsylvania. And this is, I think, this, like Dred Scott, like a number of other cases, shows the extent to which the Supreme Court, throughout much of the 19th century, was very much a pro-slavery institution. Even more so, I think, than Congress consistently was. So Prigg versus Pennsylvania is a case arising under the Fugitive Slave Act of 1793. And essentially what happens is there is a slave catcher named Prigg from Maryland who crosses into Pennsylvania, kidnaps an entire family of free black citizens. So these were not actually escaped slaves. Kidnaps them literally in the middle of the night, hauls them back across the border. Eventually, Prigg is apprehended by Pennsylvania authorities and is charged effectively with kidnapping. It's a more specific statute, but basically kidnapping, which is, of course, exactly what he did. And he's convicted. And Prigg challenges his conviction on the grounds that the Pennsylvania statute was unconstitutional as applied to him because it was both a violation of the Fugitive Slave Clause of the Constitution and because it was preempted by the Federal Fugitive Slave Act. These are the Supreme Court rules for Prigg. So it basically rules that Pennsylvania can't punish the slave catcher for what he did. It's a fairly strained opinion in a number of ways. For one thing, the Fugitive Slave Act, which the court says preempts the Pennsylvania law, sets up specific procedures that slave catchers have to use if they're going to capture escaped slaves and take them back. And Prigg didn't follow any of those procedures. So it's hard to see how the Fugitive Slave Act would have come into this at all. And the Fugitive Slave Clause hadn't been thought previously to be self-executing, nor had it been thought to give a right of self-help. Or the Fugitive Slave Clause, a more charitable interpretation of it perhaps might be that it allows the state, that it gives an obligation to the states to set up procedures to return escaped slaves to their masters. But what the court says in Prigg versus Pennsylvania is, no, the Fugitive Slave Clause by its own operation allows a private citizen like Prigg to go in the middle of the night and dragoon people out of their bed and haul them off to the south. And, of course, these people had never been slaves at all. The court essentially takes one of the most odious clauses of the Constitution, the Fugitive Slave Clause, one of the most odious laws in American history, the 1793 Fugitive Slave Act, and makes them both worse.
Dred Scott v. Sandford is an 1857 case in which Dred Scott, who was a slave, sues for his freedom. And he does so on the basis of having traveled with his owner into non-slave states and especially into the federal Minnesota territory where slavery was prohibited. So his argument was, since my owner took me to this place where slavery was prohibited by federal law, I should have been free as a matter of that federal law. The Supreme Court says no, and it does so by answering two questions. The first question that it has to answer is whether Dred Scott is a citizen of the state of Missouri, where he's suing from, because one of the ways that federal courts get jurisdiction under Article 3 is when a citizen of one state sues a citizen of another state. The idea was the state courts wouldn't be able to be particularly neutral in those circumstances. They're likely to be biased toward their own state citizen. And so the federal courts should be open to people who are suing someone from another state as a potentially neutral institution to arbitrate their disputes. But it requires that a citizen of one state sue a citizen of another state. And the question is Dred Scott a slave or a former slave, depending on the outcome of this case? Does he have citizenship in the state of Missouri? Every first-year law student learns if there is no jurisdiction in the case is over. Should be done, right? Roger Taney should have stopped right there. His reputation still wouldn't have been that good because he said all these nasty things about what people thought about the capacity for African Americans to be citizens and people even. But his reputation might have been a little better had he stopped there, but he doesn't stop there. And so the second question he asks is whether the federal law that made Minnesota a free territory was constitutional. And that federal law was the Missouri Compromise, which said certain territory above a certain line was free and territory below a certain line was slave. And what Roger Taney says is that law was unconstitutional. Dred Scott v. Sandford in 1857 is the first time the Supreme Court strikes down a law that Congress has made since Marbury versus Madison in 1803. This is a really big deal. The other reason this is a really big deal is the reason that Taney gives for striking down this law. And what he essentially says is that slaves are the property of their owners. And you can't just take away that property, that the owners essentially have a due process right to their property, a substantive right to own their property and control their property as they want to, no matter what. What does this do to the power of the Supreme Court? It aggrandizes it once again, right? If you think, as people did when the Bill of Rights were ratified, the Bill of Rights lists these rights and these are the only rights, then that gives the court a lot of power, but not unlimited power. What Roger Taney does is extend the power of the court and the rights of individuals to what he would think of as natural law, the natural law that people have in their property, and that Congress is not allowed to take property from A and give it to B. And so this interpretation of the Constitution as protecting unwritten rights, unenumerated rights, natural rights, is yet more power to the federal judiciary to interpret the Constitution almost however they want, right? That's what the criticism says, however they want in order to find natural law to protect some people against others.
I think that Taney in Dred Scott wrote a really expansive opinion. Leave aside which way the case was going to come out. He wrote an incredibly expansive opinion because he thought he was solving the problem of slavery. Effectively, what he does is to sort of ensure the rise of the Republican Party as a national party. Since the Whig Party had largely fallen apart, there was this succession of small sort of splinter parties that were anti-slavery, but were sort of looking for something to organize around. And it's really the Dred Scott opinion that gives birth to, or that gives the sort of final push to the development of the Republican Party, which of course then makes Lincoln its nominee in 1860. And in the Lincoln-Douglas debates, Lincoln talks a good bit about Dred Scott and says, even if I am bound to respect the judgment of the court, which is to say respect what it has to say with regard to the individual named Dred Scott, Lincoln says, I don't have to accept it as a political rule. So I don't have to accept all of its really expansive language about, all the federal territories have to permit slavery. Right? Lincoln says, as president, I wouldn't respect that, even if I would be constrained to respect the actual judgment of the court.